Hey gang, this is Ben with BHANDLAW, and in today's weighted walk, I'm going to be breaking down the U.S. Patent and Trademark Office's refusal of the owners of what is now called the Utah Hockey Club, their trademark registration application for Utah Yetis. First takeaway is that you want to avoid 2D refusals, if at all possible, as much upfront. So anyways, how can you minimize the chances of a 2D likelihood of confusion refusal? Well, the easiest thing to do is do your legwork, do your research, do your due diligence on the proposed trademark up front. Okay. There are plenty of free resources. One of them is called the internet that you can use to do a search. And it's not the holy grail, it's not the end-all be-all, but it's going to get you a good chunk of the way there in terms of finding out or determining whether there's any potential conflict in the name that you want to register and one that is already out there, whether registered or not. The USPTO has a searchable database online. You don't need to have a membership or registration or anything. You can just fire it up and enter the words or the characters or whatever, and it can get you a good chunk of the way there in determining whether you've got a problem or not, okay? So you want to really try and reduce your risk of a 2D refusal by picking a good name for your brand or your particular good or service that is distinctive and, more importantly, to this point, is not already taken, okay? And so I promised I would get into why exactly the USPTO had a problem with the Utah Yetis, and I'll do that right now. And that is, there are already two quite well-known and I'm guessing well-resourced companies out there who have the trademark Yeti. One of them, as most of us know, is the cooler company, whereas the other company is a cycling company. I don't do as much mountain biking as I used to, but I know enough to know the name Yeti Cycles or Yeti Cycling. And so guess what? Unsurprisingly, both of them registered or have attempted to register in class 25, which, remember, I said was apparel or clothing. The same category or one of the categories that the ownership group of the Utah Hockey Club is trying to register in. And so, but, you know, this to me seems or smells or smacks of, you know, I think they just took a flyer on it. I think a first-year law student would have been able to see that, you know, look, Yeti Coolers is already there, Yeti Cycling is already there in class 25. This is a suicide mission. And, you know, and I think the Utah Hockey Club ownership group, if I had to guess, we're just like, it's fine. You know, how much is it going to cost? Because other than the pain and humiliation of being refused, there really is no penalty to you for being refused or being denied, okay? So, you know, the worse that you're out, like I usually tell clients who are insistent on still damming the torpedoes full speed ahead, I tell them, well, you know, you're going to be out whatever you pay me, and you're going to be out the filing fee. So, you know, that's not good as it is. But other than that, it's not like you're wholesale prohibited or prevented from using that name, at least until another party who has a senior claim or senior rights to that name decides to make it a problem. That's, again, is outside the scope of this video. So that's takeaway or nugget number one for you entrepreneurs and business owners out there. Takeaway number two. Okay, so merely adding the name Utah or any geographical descriptor or pluralizing your proposed trademark, in this case, adding an S to Yetis to make it plural, is not going to be enough to either A, make your trademark distinctive, which is kind of the holy grail when it comes to the standard, when it comes to getting your trademark registered, but moreover, it is not going to be enough to overcome a 2D refusal. What I mentioned in the first part of this video, the likelihood of confusion. And the reasons for this are several. But the short version is basically we don't want people being able to carve out a little, what I said before, monopoly on terms like, I don't know, the each of the United States, or being able to, tack on an S to a particular word, okay, or pluralizing it. That is just not going to be enough to distinguish your proposed trademark from something that is already happens to be registered, happens to be out there, okay? So, basically, if your trademark or proposed mark, if you need to add a geographical descriptor to differentiate it between an existing registration, I think it's time to reconsider. Okay, now that I'm beyond the traffic noise, we can get into, last but not least, the third takeaway for entrepreneurs and business owners. And the third takeaway or tip is standard character mark is king. Okay, well, what does that mean? I almost always will advise new companies, new businesses on a budget to apply for their trademark, whether it's a word or words, letters and numbers, what have you. Always apply. If resources are tight, always go for a standard character mark, okay? And the reasons are very clear in this case, okay? Now, it's interesting because Yeti, the cooler company, has their, as I would have done, registration in standard character mark, just Yeti, Y-E-T-I, excuse me. Whereas the cycling company registered their mark in a stylized form. So you had one that was standard character and one that was stylized, whereas Utah Hockey Club applied for Utah Yetis as standard character mark. And so while this sounds like a lot of inside baseball, the reason why it's so important for entrepreneurs and new business owners is that, brands change, consumer tastes and what appeals to them change, times change. And so you don't know between now and, 5 years from now, 10 years from now, if your logo is going to change, or even the way you present your brand or your word mark. And so when you apply for your trademark as a word mark, and specifically as a standard character mark, it does two things, all right? Number one, it gives you, like I said, a kind of semi-monopoly over the use of that word or words or phrase in commerce in the particular classes that you apply for, which we covered earlier. But it gives you that monopoly regardless of what, however you stylize it, whatever colors you use, whatever font you use, typeface, you name it, so long as you are using it as you applied for it, and that is in the same sequence as in your drawing, in your application. In this case, Y-E-T-I, in the case of both the cooler company as well as the cycling company, then it doesn't matter. You can stylize it. You can use, like I said, different font. You can make one capitalized. You can make one lowercase. You could, think of it, you name it. And it won't matter because you continue to use it in commerce as you've applied for it in the application and we're approved. And as a consequence, it gives you the broadest amount of protection and, more importantly, flexibility for how you use your mark in the future. So you take the opposite side, okay? If you have a particular way, like let's take the case of Yeti, the cycling company, they have a particular way of stylizing their name. If for whatever reason they have to change that, and that change is deemed to be significant, well, in that case, they're back at the drawing board. Okay, they have to reapply all over again because now they've changed their mark. All right. Whereas if Yeti, the cooler company, for example, I've seen their name on stuff. Usually it's white, just completely white. But sometimes it's blue. Sometimes, it could be pink, whatever. It doesn't matter. They could do it lowercase. They could do one letter lowercase, one letter uppercase. It does not matter. They still have that monopoly. They still have that protection because they've applied for it as a standard character mark. Okay, so appreciate those of you joining me on my ruck or my weighted walk. If you enjoyed this video, got something out of it, Sure would appreciate it if you would hit like below or share it, and maybe even consider subscribing to the BHANDLAW channel, where you will get notified of weighted walks where I discuss the intersection of law and popular culture, and in this case, sports, as often as I can upload them, or as stuff tends to come out. So in any event, hey, appreciate you joining me. Like I said, hope it was useful and you learned something. Catch you guys in the next one. Peace.